hope you guys are all having a good evening. This is my first time with the LSAT Unplugged group. And so my understanding, Steve, is that you guys have several of these sessions, maybe per month, where you're learning sort of LSAT tactics and then also maybe areas a little bit outside of that. So I hope that this is really helpful for you guys, just so that I get a sense for where you guys are in the LSAT law school lawyering process. For those of you who are studying right now to apply to the 2022 cycle, can you drop 2022 in the chat? And for those of you guys who have already taken the LSAT or maybe retaking it and applying for the 2021 cycle, drop 2021 in the chat, just so I can get a sense for kind of where you guys are in the process.
And
All right,
actually, also, I
2020.
was going to say, Angela, my name is Solomon. I'm a TA, so let me know if I'll be
Oh,
here.
you're gonna. Oh,
Question,
great.
and if you need to introduce yourself. So,
Oh,
I
perfect.
just wanted to let you know. But if you're good, let me know. I can introduce you, or if you can start off however. Well, just go ahead. So yeah.
Oh, no worries. Yeah, no, I just got a tip to go ahead, so I jumped in. Sorry about that.
Not a problem. Not a problem. I'll just introduce you real quick so you can be on your way. So
Oh,
everyone, this is
perfect.
Attorney Angela. I apologize for boxing. Is it Vorpahl? Vorpahl?
Vorpahl, very close.
Okay, Vorpahl. So she actually graduated summa cum laude from South Methodist University in Dallas, Texas, and she now focuses on law school prep. And today she's going to be talking about why law school is different in undergrad and how that changes everything. So yeah, you can go ahead, Angela.
Awesome, Solomon. Thank you so much for the introduction. So I just had asked a couple of you guys to drop in the chat kind of where you are in the process. And it looks like you guys are 2022 cycles. So you're really early on, which is fantastic. And I'm so excited for you guys to go through this whole process. As Solomon said, I am a law school coach. And so I help law students develop the strategies to do well in law school, to help streamline processes to compete for top grades and help position them for their dream job out of law school. And so it has been so much fun working with law students to really get the most out of law school and out of their investment. And so I know that this is coming pretty early for some of you if you're kind of about a year out, but I think it's important to start thinking about how law school is different and a little bit of what to expect so that you can kind of alter your mindset around how you're going to jump in and kind of tackle this. And so if you guys are willing, I'd love for you to drop in the chat kind of scale of 1 to 10, how you feel about law school right now. So 1 being like totally terrified and 5 being like kind of nervous or unsure, and then 10 just being over the moon excited, like could not be could not be more thrilled to like start law school. I'm just curious. I think for me, when I was starting out, I was probably about, yeah, like I don't know, a 6.5, 7.5. Okay, 5.4, like a little bit more on the nervous side. Yeah, and I think that it comes a lot from just unknown, like a lack of information about what law school is and what it looks like and how to do well. And so that's what I focus a lot of my work on, is really trying to help fill in those gaps so that you know what to expect and you know what those strategies look like. So it's not just kind of this black box of information. And so in our talk today, I know we're focused on why law school is different than undergrad and how that makes all the difference in the world. And if you guys have questions, I'm incredibly happy to take those at the end. So feel free to just drop them in the chat box as they occur to you. And then we'll have a Q&A session at the end as well. So I think the most helpful place to start with respect to this conversation about law school and how it's than other academic experiences is to look at what our academic experiences have been to this point and how that perspective has really informed how we view law school. I think that's really important because for most of us heading into law school, our academic experiences have been really positive and have been really, really successful. And so a lot of law students heading in have done really well in undergrad or grad programs, really well in high school. Most of the time that's come easy to people. There's also this, I get this a lot from students, that I was able to get good grades and I didn't really have to work that hard. A lot of people will cram for exams and things like that. And so what tends to happen is that the perspective of law school is, why would that be any different? So I've always been able to hit or exceed my grade goals. I don't have any evidence or reason to believe that that won't be the same in law school. And so that is absolutely how I felt heading into law school too. Is why would this be any different than anything else? And I think that those expectations and assumptions are really important to recognize that we have them, and also to really break them down for what they are. Because the statistic is something like 80% of law students think they're going to be in the top half of their class, and 50% of law students think they're going to be in the top 10%. And mathematically, that's impossible, of course, but it's really important to recognize where that's coming from, and also that that's kind of our mentality heading in, so that we can challenge those beliefs and kind of understand what we need in order to really make that possible. And so the first thing that is important to recognize, the difference between law school and undergrad, are the pool of people that are going to be your classmates. Because for a lot of us, our experiences of being at the top of the class and A's coming easily to us, and not really having to work that hard, we have been in a pool of people that have had a variety of academic goals, right? So it kind of has run the gamut of whatever those goals, aspirations, work ethic, motivations. Everybody is kind of in their own boat in terms of how important school is to them. But when you get into law school, that pool becomes much more of a self-selected minority of people who are highly motivated, incredibly hardworking, very goal-oriented, very grades-oriented. And so the the people that are your classmates and that are surrounding you are necessarily going to become this subsection that is much more competitive, and much more academically focused. And the reason that that is so important is because of the next big difference between law school and undergrad, which is how law school is graded. And in undergrad, there is no limit on high grades, right? So everybody hypothetically could score between a 90 and 100 on an exam and get an A. There's no quotas that have to be met. But in law school, grading is completely different. So you may have heard this before, but law school is graded on a curve. And every law school does this a little bit differently. But essentially, professors are required to assign a certain number of A's, a certain number of B's, C's, D's, F's. And so it tends to take the shape of a bell curve, where the majority of the class is focused in the middle, at the B range. So majority of the people in your class are going to get B's. A very small percentage are going to get A's and A minuses, and a very small percentage are going to get C's and F's. And the reason, of course, that that's important, and that really implicates the people that are in your class, is because you are going to be directly competing against other people in your class. Because again, every law school does this a little bit differently, whether it's a median GPA or a set number of letter grades that have to be hit. You are generally going to see in a class of 100, maybe 5 A's, maybe 10 A minuses. And so those are really, really, really small percentages of people who are breaking out of that B pack and getting into the A pack. And so that alone is what makes law school so incredibly competitive. And that may be some of the horror stories you've heard that are not entirely true, but of people like ripping pages out of books in libraries, and like stealing computers, and stealing notes and things like that, to try to get an edge, because of the idea that law school is so competitive. And that stuff like very rarely happens. But the underlying sort of drive of that is that, yes, law school is incredibly competitive, and you're competing against very capable, very highly motivated people. And so that is one of the biggest differences, and one of the things to keep in mind as we go through this. Now, one of the things that I do want to address kind of before we go a little bit deeper into this, a little bit of an elephant in the room, is that every single law student, every single lawyer has gotten a grade in law school that they are disappointed by. Absolutely, it has happened. Even for those of us who are, straight A students from kindergarten, have never seen a B in our life, it is inevitable that you will get a grade that you are not expecting and that you are not incredibly happy with. I have talked to motivated, intelligent, hardworking lawyers who've gotten their first C in law school, that have gotten their first D in law school, and certainly have gotten their share of Bs. And so I tell you that not to change your grade goals or change your motivation around what it is you want to accomplish in law school, but just to give you that sense of deference and respect for how difficult this process really is and how incredibly capable the people around you are. And I think that that's helpful to have that sort of healthy level of fear or of understanding that this is a lot of work, especially if your goal is to get to the top of your class. That this is something that is going to take more effort and more strategy than what you probably put into undergrad or grad school, or your other academic experiences. I also bring this up because the truth of the matter is, because of the curve, that 90% of law students are not going to be in the top 10% of their class. So mathematically, that is how it's going to play out every day from now until that curve no longer exists. Which in our system, it has existed for a very long time. And so I don't want you to think that if you are not in the top 10% of your class, that that means that you are not smart, that it means you're not hardworking, that it means you're not going to be a successful lawyer or have a successful legal career. That's not what it means at all. I tell you this because there are a lot of lawyers out there that did not do particularly well in law school, that have incredibly amazing careers that they love, that they're passionate about and very fulfilled by. The other side of that coin, however, is that you are spending a ton of money, a ton of time, you're investing a ton of your life into this degree. As long as you're going to go through the process and put in the long hours and spend those long nights, as long as you're going to do all those things anyway, we may as well go all in and leave everything on the field and do as well as you possibly can, because there's no reason not to. As long as you are going to do this thing, as powerful as these grades are, which we'll talk about a little bit later, you may as well go for it. And so that is, I think, something that is really important to keep in the back of your mind in terms of how you approach grades, what this system is of who you'll be speaking or who you'll be competing with, and how much effort it's really going to take to be able to compete at these very, very high levels of your class. So let's dive in a little bit in terms of what you can expect from law school and how that's different than undergrad. And the first way that the content is going to be different is the way that the information is presented. So in undergrad, everything, I say this as generally speaking, right? Most courses, most majors, there's a direct through line with what you are taught and what you are graded on the exam. And so you are generally assigned to read pages in a textbook, you have class lectures, PowerPoint presentations. There's no hide the ball tactics. It's very much, here's the information you need to learn, and then the questions on the exam are asking you about that information that you were just told to learn. So in law school, in law school, the information that you need to learn is the law, right? Which makes total sense. It's the rules of law, but the way the information is presented is anything but direct and straightforward. So the things that you will be reading to help teach you these rules of law is not just a textbook saying, this is the rule for how property gets transferred, or this is the rule for when somebody is liable for assault. Instead, the way that you're going to be learning these rules, the way that the information is presented, is through a case book. So you are going to be reading cases in order to learn these rules of law. And a case is, we call them cases, but what they really are judicial opinions in previous legal disputes. So litigation, someone has sued someone else, and the judge has been asked to give an analysis and a holding on a rule of law. And so what's super interesting about this is that even though the goal of the case is to teach you this rule of law, it is reading a case to learn a rule of law is the most convoluted way to actually learn what that rule is. And so real time, what that looks like is you may be assigned a 45-page case, incredibly dense material, legalese, very circuitous reasoning to teach you that the standard of care is that of a reasonable person. And the kind of 1-2 punch of how this information is presented in law school is that you have the reading part of it, which are these cases which are not telling you exactly what the law is. It's sort of asking you to figure it out for yourself. Then you have lectures, the other part of teaching you the law, and professors will at least at the beginning of class start out not telling you what the rule of law is. And so the way that a lot of lectures are traditionally presented in law school is through the Socratic method. And so you guys may have heard this term before, and it's very much what you would think of based on the way that Socrates taught, which is this dialogue between a professor and a student, questions and answers, where the professor is basically poking holes in whatever it is you're saying, and your explanation of the rules, and in your analysis of a particular fact pattern, to try to get you to see that there are the strengths or the weaknesses of an argument, or get you to question why we have the rule we have, or how you think through it. And so the reason that the Socratic method is so popular and it has sort of ruled the classroom for so many years is that law schools believe that they are designed to teach us how to think like a lawyer. So they're designed to get us to look at a set of facts and not only drill down on what the most important facts are, but also be able to see the outcome from different perspectives, able to see how to argue it from one side and from the other side. And so that's what law school is designed to teach us. And so that's how professors tend to operate in their classrooms. Now, the reason that this is really tough and very different from how undergrad is structured is because you are still required and you are still going to need to learn the rules of law. When you think about it, you're not getting them directly from the cases. And a lot of times you're not getting them directly from the professor either. And so you have to go and find ways to directly understand what these rules of law are and then how they apply in certain factual scenarios. So one of the biggest complaints about law school is that it has an approach of hiding the ball, meaning you don't really know what the rule is. You don't really know what their information is, and it's up to you to figure it out and to find it. Now, some professors, I would say the majority of professors, the other half of their lecture, the other part of their lecture is going to help you walk through the information. But for some professors, they're very, very upfront about the fact that it is not their job to teach you the law. It is their job to help you think like a lawyer, in quotes. And it's your job to go outside of the classroom and teach yourself the law, which is really crazy. And one of the big, I would say a really big complaint of a lot of lawyers and law students about how the system is created. Okay. So the next piece to this puzzle, how it's different, is you have the way that the information is presented, but then you also have, it also informs how these law school exams are structured. And so in undergrad, again, like there's that direct through line of what you're taught. So what you read, what you're taught in lectures, what if you have homework, what that homework is designed to teach you, and then the exam, what you're required to sort of recite or parrot back or regurgitate. And it's a very, very clear line connecting one to the other. In law school, it very, very much is not a clear line between what it is you're taught and how you're going to be tested on the exam. And so in law school, you're never going to have an exam that asks you a question like, what are the 4 elements of negligence? Or in what year was Plessy versus Ferguson decided? Or what is the holding of the Lucy versus Zemmer case? It's never going to be something that's sort of just recitation or parroting back. Instead, the way that a law school exam is structured is all about application. And so you are going to be required to take these rules of law that you learn throughout the semester and the examples of how those rules have been put into practice through cases. And you are going to be asked to apply them to a hypothetical factual scenario, which is going to be on the exam. And so these types of exams are known as issue spotters, and they are the most prevalent type of exam in law school, especially your 1L year. And so what's interesting is that the rules of law that you are going to be expected to learn from these cases, from the lectures, and then from outside sources that help you sort of piece these things together, is that you need to know the rules of law, but that's sufficient. It's what is it? Required but not sufficient, necessary but not sufficient. You also need to develop the skill and develop the muscle to be able to apply those facts to those rules to a factual scenario. And so I know that this isn't a how to take a final exam course. That would be much more extensive. But the thing I do want you guys to understand, the most important takeaway, is that for final exams, we're never looking for the right answer. I think it's really, really hard for us to wrap our heads around. And I see this being one of the biggest struggles for new law students, is that we are so programmed to find the right answer, whether that's algebra or physics or history. It's We have always been taught that there's a right answer, and all we need to do is find it and then recite it back, and that gets us top grades. In law school, the thing to start thinking about and to start wrapping your head around is that there is no right answer. There are only good arguments. And so this whole idea of thinking like a lawyer is designed to help you see how to attack or approach a dispute from multiple angles. And so on a law school final exam, like we said, you're never going to be asked to recite facts or rules. You are going to be asked in an indirect way, of course, to be able to argue a dispute from one side and argue a dispute from the other side. And so that's something that's really important in terms of mentality and approach to law school, is understanding that not only is the information presented very differently, but the way that the structure of the exam, the way that you're going to be tested is also very, very different. That takes us to the next big difference between undergrad and law school, which is how you study. Because if we're going to have these crazy exams that are totally different from undergrad, the next question becomes, how do we prepare for them at all, right? And so in undergrad, I think for the most part, a lot of us didn't have sort of a well thought out study strategy. We did the reading, maybe. We took class notes, maybe. We did the homework, maybe. And then we really turned up the intensity when there was a midterm or an exam or a paper or a presentation, like something big and graded, right, that was coming up. And that's when we sort of put pedal to metal and accelerated our energy and what we kind of how we applied ourselves. And we were able to do that. And I hear this from a lot of students as well, and able to cram for exams at the last minute and really still kind of put in that last ditch effort and still get A's and still do really well. In part, that was because, again, the way that it's structured is very straightforward memorization and recitation. So if you were good at cramming, if you were good at sort of internalizing a lot of information really quickly, you could still get A's in a very short amount of time. The other reason that it was possible is because there was no max number of A's. So if you remember the information, you recited it, you could still get an A, even if every other person in that class also got an A. And the other reason that that was possible for a lot of us in undergrad is because we were being tested on smaller chunks of information. So we were required to retain less information, and we were required to retain it for less time. And so maybe you were tested like every 4 weeks or every 6 weeks or even every 8 weeks. And that was still very, very possible to internalize. And because you had all of these different opportunities to be graded, you could blow one exam or blow a quiz and still wind up getting an A in that class. And that's really important to understand because law school is completely different. The way that you're tested and the way that the final exam is structured and weighted is very different. So most law schools across the country will have one final exam at the end of the semester that's 100% of your grade. There are law schools that are starting to have midterms and break down the grade into quizzes or participation, but still, at least right now, a lot of those are either not graded or they're like a very, very minimal part of your grade, something in the range of like 3 to 5%. So very negligible. And so what that means is that for one exam that's 100% of your grade at the end of the semester, those 4 months of studying and reading and late nights and organization of the material comes down to one 3 to 4 hour exam, which is crazy stressful, and a really, really tough, makes for a really, really tough 2 week period to really go all in. And this means a couple of things, right? So big difference with undergrad, but in terms of how that plays itself out is that you are going to be expected to have learned 4 months of information as opposed to maybe 6 weeks of information in undergrad. You're not going to get another chance, another bite at the apple. This is like a one and done thing. This is 100% of your grade. And as we talked about, the exam isn't memorization based, it's application based. And so it's not enough to just know the rules. You also have to know how to apply them. And so the biggest takeaway here is that you cannot study in law school the same way you studied in undergrad and expect the same results. It's just not going to be possible because of the structure and the format of the courses and of the exams themselves. And what that sort of translates into in the day to day is that you can't rely on short-term memorization and regurgitation, and you can't cram for final exams at the very end of the semester. It's just not going to leave you enough time to be able to internalize all this information and learn how to apply it. And so a really big takeaway for that is, instead of a cram at the end type mentality, the absolute best way to approach law school is a semester long study strategy where you are literally starting to prepare for exams from day one of law school. Okay. That's a really, really important takeaway, a really, really important difference. And I think something that sort of plays into that, kind of the second part of that too, is to understand that the other piece that makes law school really difficult is just the straight up workload, the amount of information that you are being taught and fed and required to know on a daily basis and on a weekly basis. Because I would say that in undergrad, and I think this is pretty similar across the board, the work is manageable. So it is physically possible to read everything you're assigned in class and take notes in class and review all of those for the exam. Like, that is physically possible to do. In law school, it's not. There will always be more information and more ways to learn and practice that information than there are hours in the day. And so the thing that makes this so tough is that from day one, in law school, you're absolutely inundated with information. You are going to have on average, about 100 pages of reading a day. And that keeps going. It's fast and it's furious and it's constant. And you're learning new information all the way up until the last day of class, which tends to be about a week before your first final. So there's just no way that you could wait until the end of the semester, try to learn 4 months of information in a matter of days. And so we just don't have the luxury of waiting and cramming. The study process has to be this ongoing process that you are chipping away at and taking steps toward every day, every week of the semester, starting from day one. And what I would say absolutely is the key to success is learning how to manage the workload, because if you fall behind, it is virtually impossible to catch back up. There's just too much information that is coming at you too quickly to allow yourself to fall behind and then try to double up, triple up, or quadruple up the amount of work you're in your day to day to prepare for final exams. And the key to keeping up with that workload is knowing what to spend your time on and when to spend that time. And so those things really, really go together, because, as I said before, there's no way to do all of the things. And so you have to get really clear and really strategic about what you're spending your time on, what those things look like, when to focus on them, and what to actually focus on. And I know this really sucks to hear, because if I had said this to past me heading into law school, I think I would have been a bit heartbroken. But in law school, if your goal is to get to the top of your class, straight up hard work isn't going to be enough. You cannot white knuckle your way through law school, meaning just do all the things and like hunker down and stay up till 4 a.m. reading all the things and studying all the things. It's going to be too much. You need to also be strategic about what it is that you're doing and how you're doing it in order to position yourself by the time that law school finals come around to be able to perform at a high level. So that's another big difference between undergrad and law school. Then I would say we're talking a lot about grades. We're talking a lot about the importance of grades and how you go about really strategically managing grades. And the reason that this is so important, and the reason that a lot of what I'm talking about today, exclusively what I'm talking about today, is grades oriented, is because your grades in law school are incredibly powerful. Legal industry is very grades obsessed. It is very grade centric, and every legal employer will look at your grades before they will look at any other part of your application. And this is particularly relevant for 1L because your 1L year grades are going to be disproportionately powerful to any other grades that you have in law school. And the reason that that is the case is because the most extensive hiring process in law school happens at the end of your 1L summer, beginning of your 2L year. You guys may have heard of this process. It's called OCI, or on-campus interviewing. Some law schools call it EIP, early interview program. And that happens very early on in the process, 1L, end of 1L summer, beginning of 2L year. And we just said law firms and legal employers are going to be the most influenced by your grades. And the only grades you have at that point are your 1L grades. And so those first year grades become your ticket into a lot of these opportunities and a lot of these doors opening for you. And so the thing to know about this OCI process, or this hiring process, is that it's very competitive. And so it depends on what law school you go to as to how high you have to rank in your law school class in order to participate. But just to give you a rough idea, if you're going to a T14 law school, they generally will want to see you in the top half. As you go kind of down the rankings into more regional schools, we're looking at top third, top quarter, or top 10% to really have all of these opportunities open to you and have you be able to compete for interviews. And so I would sort of kind of, to put this in perspective, if in undergrad it worked the same way and your freshman year grades determined whether or not you could apply to your dream job out of college, of course you would put a ton of energy, a ton of effort, and a ton of time into really getting those grades as high as possible. And so that is why you'll hear such an emphasis on first year. And kind of hand in hand with that, your first year is also your most difficult, because everything you're learning for the first time. It's brand new. There's a huge learning curve. And so not only is it the most difficult, it's also the most stressful, because you know that it is not only competitive, but has the opportunity to open you up to these really prestigious, really high paying jobs. And so one of the things that I always talk with my students about is kind of what we at the beginning of this talk, which is, no, you do not need to have the highest grades in order to have a successful career in the law. But I want to give every student I work with that ability and the steps and strategies in order to do that, so that you can decide what jobs you want and how you want your career to look. And you have control over those decisions rather than the market or the legal employer dictating that for you. And so that's why we put such an emphasis on grades. That's why we put such an emphasis on the study process, not only because it is very foreign and very different to what we're used to, but also because it makes a really big difference in terms of the opportunities available to you. So let me check out the chat and see if anybody has any questions. I'm happy to ask. I'm happy to answer anything that you guys would like to know. But yeah, thank you guys so much for having me, and I hope this was helpful. I hope you guys were able to take something away.
Thank you so much. We appreciate you, Angela. Did you prefer the questions? Did you prefer me ask, or did you want people to ask through the chat? What's easier for you? Or
Either way, you guys can drop something in the chat, or if you want to unmute yourself and ask a question, either way, I'm available.
okay, cool. I'll just kind of start it off, and then if anyone has a question, like she said, you can drop it in there. If you're too timid, you can just kind of funnel it through me. No, this is really helpful. I appreciate you sort of going through this. One thing I always try to ask, I guess lawyers are, hey, how do you prepare for law school? And the answer is always, you can't really prepare for law school.
Yeah.
So I was curious, as I know, and I'm pretty sure you've heard of the IRAC method, right? Like the issues, the rules, analysis, conclusion, all that stuff. Um, I guess I was curious because since it is graded on the curve, so assuming that I guess students are able to address each of those things in the IRAC, what would you say separates the 10% of students from the 50%? So the top 10% from the 50% in terms of how they're addressing those issues on the examination?
Yes, really, really good question. So and just to kind of loop everybody in. So the most traditional way to approach a final exam answer for one of these issue spotter exams where you have a fact pattern and you have to spot the issue, identify the legal rule, and then analyze that legal rule as it applies to the facts is the IRAC method, which stands for issue rule application or analysis conclusion. And I love that method. Like I think that the reason I like it, it's simple and it's direct. And so you can keep it in your mind as you're going through these exams, which are crazy fast races, like 3 to 4 hours just flies by. And so having that framework in your mind is fantastic. The thing to keep in mind that separates sort of like to break out of the BPAC, right? So to separate you from the median, is that everybody will get the biggest issues. And so in these fact patterns, they're intentionally ambiguous. They're intentionally in that gray area where there is no right answer. And so what tends to happen is that a lot of law students will go into the exam thinking, what is the right answer? And so if you have a fact pattern for civil procedure, for example, you'll start reading the fact pattern and you're like, I see it. That's definitely personal jurisdiction, or that, venue definitely exists. And so they'll write their answer with the right answer in mind. So they'll identify the strongest arguments. They'll identify the strongest facts that back up what they think that answer is. Unfortunately, even though that's a great start, most everybody will get those big issues and most everybody will get those big arguments. The way that you start moving up the chain from B to B plus to A minus to A is identifying the counter arguments. And so what a lot of people, either they've heard it, either they haven't heard that you need to address arguments and counter arguments, or they've heard it, but they don't really understand how to do that. They'll leave so many points on the table because when a professor is grading law school exams, they usually do it by a rubric, and they have kind of, maybe an Excel spreadsheet saying like, here's all the issues that I put in the fact pattern. Here are the facts that people can argue. Here are the arguments and counter arguments. And so a lot of people get the big stuff, but very few people get the more nuanced issues, the counter arguments. And so what I would say is that to start moving yourself up the chain, you have to adopt this mentality of argument, counter argument. You have to adopt this mentality of no right answer. Because if you don't, you'll just be leaving all of these beautiful points on the table for these facts that can be argued one way and the other way. You can see it from the perspective of the plaintiff and the defendant. And so that is the biggest thing that students struggle with, and the biggest reason that they struggle to move out of the BPAC and up the chain to A's.
Wow, thank you so much for that. And then one of our future lawyers asked, are there any techniques in the note-taking process as we first transition into law school?
So many. Yeah, so many. That's so funny. Okay, so yes, the answer is yes. Huh? Oh, I thought there was a question. Okay, so the short answer is yes. I have so many approaches to note taking that is really, really, really helpful and kind of streamlines the process and helps you focus on the things you need to focus on. The number one thing I would say is that most law students get buried in the reading. So when you're talking about 100 to 150 pages of cases that you have to get through every day, it is an insane amount of work. You also, because of the way that these cases are written, they're not super straightforward. They're not light reading. Like they're very dense. They're very confusing. And so a lot of us we need to read it 2 to 3 times just to understand what is going on. And so that number starts getting doubled and tripled. And so what I always recommend is before you sit down to read this 15, 30, 45 page case, to always know what the case is about before start reading it. And so the easiest way, because as we talked about, the cases are designed to teach you a rule of law. Like they're there for a reason, but the reason that law school is so, the presentation of the information is so difficult is because when you read a case, it's sort of like, hey, you figure out what that rule of law is. You figure out why we're assigning you this case and what it's meaning to teach you. And so to bypass that in huge time investment and that confusion is to figure out what the big takeaways of the case are before you start reading it. And the best way to do that is to read a case brief summary before you actually read the case. And the most popular right now are Lexis and Quimby. And so essentially what you're doing is finding the golden egg. Like you find the answer before you invest 3 hours in reading a case so that you know what to look for, you know what the big takeaways are. And then as you read the case itself, it's so much easier to identify the facts that are important, the rule that's important, the analysis that's important, the holding that's important, because you already know what the game is. Like you already know what that answer is. And so that's number one thing I would say about time management and note taking is you have to do yourself that favor. Otherwise, you're going to fall into this well of reading and reading and rereading and 150 pages a night, and you will never actually move on to any other steps of the study process that you need to prepare for final exams.
Awesome. And they said, thank you for your answer.
Yeah, so
You mentioned Lexis and Quimby. Could you spell the Quimby? Is that Quimby or?
sorry, yeah, Quimbee.
Okay.
Yeah, and so Quimby's great. There's definitely other supplements out there, but right now that one is I would say the favorite among my students because they do a really good job of breaking down the cases into incredibly basic parts so that you can actually figure out what the case is saying before you invest the time into reading it word for word.
Awesome. And I had two questions, but I'll ask one first and then see if anyone probably go to the next one, which is you kind of sort of going back, I guess, to the exam format. I was going to ask, how long is the exam typically? Is it about 2 or 3 hours? And then is it just one hypothetical or are there multiple hypotheticals in which you have to address?
Good question. So generally speaking, law school exams are 3 to 4 hours, and they will usually be the amount of hours that is the same as the amount of credit hours. So if the class is a 3 credit hour class, it's generally a 3-hour exam. It's a 4 credit hour class. 4 credit hour class, it's a 4-hour exam. And I had some 2 credit hour classes, 2-hour exams. So that's generally how they break it down. The professor gets to decide how he or she wants to structure the exam. And so issue spotters are the most common type of exam style that you'll see, especially 1L year, which is the fact pattern and then a very open-ended question, something like discuss all claims and defenses of all parties. And it's up to you to figure out what claims, what legal rules are at issue, which is like the issue spotting we talked about. The other type of exam is call a short answer, which is essentially the same as an issue spotter. It's like, I call it an issue spotter short answer to not confuse things. But basically it tells you, the professor tells you what it is he or she wants you to talk about. And so, for example, instead of just saying, discuss all claims and defenses of all parties in the fact pattern, it might say something like, does P have a claim for negligence against D? So now you know, okay, this question is specifically asking me to talk about, negligence. The other types of questions you could get, again, the professors have full liberty to do whatever they want, but usually it'll be issue spotter short answers, multiple choice. Like usually you'll have a handful of multiple choice questions, which are not any easier, by the way. Like they'll just be shorter fact patterns. And then you have to do the same thing, spot the issue, identify the rule. It's just that you don't have to write out the answer, right? The answers are there and you pick one. And then choice policy questions don't show up that often, but they're not that many usually, but they can be there, which is policy is about why we have the rules that we have. And so they'll give you a hypothetical about like a potential statute that Congress made up, but a potential statute that Congress is thinking of adopting. And then you have to analyze the policy behind adopting it or not. That's another one. You could also, they could also do true or false. They also do fill in. I've like recently heard one of my students has a fill in the blank. So there are other pieces, but the only thing I would caution you about pieces is that if you're talking about short answer, fill in the blank, true, false, or multiple choice, those point totals are set. There is no physical way to get more points than is allocated to those questions. But for an issue spotter or an issue spotter short answer, there is no cap to the amount of points you can get. And so even if this over here is taking up a portion of the exam, I caution students to just keep in mind, let's just assume everybody in the class gets all of these right. We still want to maximize the point totals that we're going to get on issue spotters, because if this is a wash over here, then the issue spotter becomes the entire basis of the curve. And so like, that's the only thing to kind of keep in mind, is that the cool thing about issue spotters is that you can accumulate a lot of points, and the other types of exams are just set in stone. So yeah, another a little in the weeds on that answer, but like I hope that was helpful.
No, thank you. That was helpful. And before I'm gonna someone asked a question, I was gonna just clarify. So because I was asking about a hypothetical. So what you're saying, there are a multitude of things from the hypothetical to the fact patterns and the multiple choice, which I was like, oh, multiple choice, like you said, it's not any easier. So that's
right.
That's funny. So just to clarify, so typically from what I'm, so there probably would be just one hypothetical and then to make sure the other things, or could it be more hypotheticals or?
Yeah. So yes, it can be anything, but I guess to give you like some examples. So for a 3-hour exam, the professor might do all issue spotters. So he or she might do 3 fact patterns, each an hour long. They might decide to do 1 long fact pattern issue spotter and 2 short answer, and also 15 multiple choice and 1 policy question. So it can be any combination of those. But I guess what I would say is I've never been on a final exam where there's just one like massive 5-page fact pattern, like with 1 big question, talk about everything. The most massive fact pattern I think I ever had was in torts. And I think there were 2 fact patterns that were like 3 to 5 pages each. And that was a class. So we would have an hour and a half on each fact pattern, but that's like that's like the most massive fact pattern I've ever seen. Like nowadays, I would say that professors, you can probably expect about an hour per fact pattern, 45 minutes, 30 minutes for a short answer. And so they'll almost certainly be breaking up that time into multiple things rather than just like one massive fact pattern.
Thank you for that. Appreciate you. One of our future lawyers asked, for those who know that they want to go for a clerkship, how pivotal are grades and the ranking on the school, and what point, and at what point should they start scouting for clerkships?
Start scouting for coaches. Can you ask a follow-up question about maybe what they mean by coaches? But I'll speak to the rest of
I meant to say clerkships. I said coaches.
Oh, clerkships. Okay.
Oh yes, I can read it again. So for those, who know they want to go for a clerkship, how pivotal are the grades and the ranking on the school, and at what point should they start scouting for clerkships?
Perfect. So just to loop everybody in, judicial clerkships are considered very, well, I guess yours is. So judicial clerkships, what they are is you are working for a judge in that judge's chambers, usually for about a year. Some clerkships are 2 years, and there's career clerks, but by and large, you're talking about a 1-year job. The job of that clerk is to help the judge research and draft opinions. And it's the best job. If you're interested in litigation, it is the best job that you can get out of law school. It gives you, it's like crazy that they let brand new baby lawyers even do this work, but it's tradition. And I assume it's working out okay because they keep doing it. And so, yeah, you get to see behind the scenes, you get to see how a docket is run. You get to see how judicial opinions are drafted. Like, it's crazy. It's really, really fun. There are 2 tiers to judicial clerkships. You can have state clerkships and federal clerkships. Both are wonderful. Both will give you amazing experience. But just to make sure that everybody's just aware of this, federal clerkships are considered very prestigious. And so the reason that is important is because if you get a federal clerkship, whether that's at the district court level, the appellate court level, or of course the US Supreme Court level, that can open up doors for you in your career in a way that almost nothing else can. And so that's why they're so competitive, and there are way more people that want them, that apply for them, than there are positions, just because there's a set judges in the country, and it doesn't fluctuate. And so there's nowhere for them to create more of these positions. So that's what a judicial clerkship is. That's why it's a really big deal. And then in terms of when to start, oh, you asked about the grades. So grades are huge. Grades are kind of just like anything in the legal industry. The legal industry is very, very concerned with prestige, and the most important ways that manifests itself is the ranking of your law school and your class ranking. So if we're talking about like a T14 law school, I didn't go to a T14 law school, so I don't want to misrepresent the statistics. But even if you go to a T14 law school, you still want to get as high in your class as you possibly can, because the higher in your class, the more competitive you will be for some of these clerkships. And then if you didn't go to a T14 law school, which I did not, you need to get as high in your class. This is very, like I'm saying the same thing over and over, but as high in your class as you possibly can get. Because if you to break this down a little bit more, if you are at a more regional law school, your greatest potential for a federal judicial clerkship is going to be in your geographic area. So I went to law school in Dallas. The place where I'm the most competitive for judicial clerkships is in the Dallas division of the Northern District of Texas. Like the place where you go to law school, because the judges are aware of that law. They've heard of the law school. They probably know some of the professors. They may have even practiced there as attorneys before judges. And so that pool starts to become very, very small of where you are competitive for these clerkships. And as you can imagine, there are multiple people from your law school applying. There's multiple people from other law schools in the area applying. And we might be talking about like 3 jobs that these judges are actually giving out. And so the short answer is as high as you can get. If you go to a well-known law school, which I'm just saying T14, but T20, like a well-known law school, you can still be competitive for judicial clerkships outside of your geographic area, just because those schools bring with them brand name recognition. And so to kind of give you an idea, so I was a federal judicial clerk in the Dallas division of the Northern District of Texas. There were a ton of judges in the Dallas division. Like our courthouse was very, very full. And I would say maybe like 15 judges, and each judge usually has about 2 clerks. So you're looking at about 30 clerks per year. And I think there were 3 of us that were from non-T14 law schools. So even the judges in the Dallas division who were getting applications from the law schools in the area still opted to hire a ton of people going to name brand law schools outside of the division. Now, I'm not saying that happens all the time, but I just want to make sure that everyone is aware of like how difficult these things are to get, so that, to your point, whoever asked this question, awesome that you're thinking about this so far ahead of time. Okay, so grades super important. Next thing in your arsenal that will make you the most competitive is getting a judicial internship or externship. Those can happen your 1L summer or your 2L spring is usually when those happen. If you are applying for the cycle in law school, meaning it happens during your 2L summer, like June 15th is when the application's open. So that's the second most important thing you can have on your application, because it shows that another judge believed in you enough to allow you into their chambers, and you also understand how PACER works, like the docket system. You don't have to start from zero, and you have some research and writing experience. Okay, so that's the second most important thing on your application. Third most important thing I would say is probably your recommendations. And so to your point of like thinking about this really far ahead of time, there are certain professors at every law school that are going to have relationships with judges, either because they know them personally or they worked with them, or maybe they are expert witnesses. Sometimes like there's going to be somebody. And so what tends to happen is there's a lot of competition to get professors to write you recommendation letters, because it will start to become known what professors have relationships with judges, or they'll just straight up tell you, like, I know so-and-so judge, and I can like get you an interview with them. The reason that that's important is because you need your recommenders to ideally to know you outside of class, like to be able to to your work ethic, to be able to speak to your writing and research abilities. And the easiest way to get professors to know that is to become their research assistant. And so most professors will have research assistant positions, but those are very competitive. And so most professors, as you can imagine, will usually hire people who got really good grades in their classes. And so that's another reason to do as well as you can, because that puts you in a great competitive position to ask to be their research assistant, hopefully then to get a letter of recommendation, to then be able to apply for a judicialship if that's the end game. So all of that is to say, I would say those are the three biggest factors, or four if you want to count law school. And then starting as early as possible, creating those relationships with professors, going out for research assistant positions, getting those judicial internships is going to, every one of those things is going to bulk up your application more and more.
Awesome, thank you. And I said thanks as well for that information. So yeah, we are closing out. I was just gonna ask one last question to kind of just set us out. Yeah, I was curious for yourself, what time management skills you use either now or in law school to help you be successful, and also too as well, many of us as future lawyers, what advice can you give us in terms of skills to develop now to start preparing for law school, if at all possible?
Ooh, okay. So two really big questions. So the answer to the first one in terms of time management, crazy important. Like I would say the defining factor between people at the top of their class and then people sort of in the middle, like in the B pack, is how you spend your time, without a doubt. Like there's too much work. There are too many things to do. You cannot physically do them all in a 24-hour period every day. And so how you spend your time and how you allocate it and what you allocate it on and start and when you stop is like crazy important. What I would say is the biggest mistake that I see law students making is not having a semester long view. And so what tends to happen is that, and this was me for semester 2, is like I said, most of us never really developed like a study strategy per se in undergrad. We we winged it, and and we did what we needed to do when we needed to do it. And if you have like a day-to-day or a week-to-week mentality, structure, approach, you're going to get buried by the work. It's just going to happen, and you're not going to be able to carve out enough space for your time at the end of the semester to prepare yourself for finals. And so in terms of time management, what I 100% always recommend is looking at the end game first and then backing yourself out of it. So look at where you want to be by the end of the semester and then set progress points for yourself going backwards in time so that you can really see, oh my gosh, I need to start outlines by this date. I need to finish outlines by this date. I need to take this many practice exams. Is that going to happen? These progress points have to be set from day one so that you can stay true to them and you can honor that time that you have reserved for each individual activity, so that you don't get swept up into this kind of mire of reading thousands of pages and then never moving on to another study step. So that would be point one in terms of time management. And the second thing you asked, steps you can take now to prepare yourself. So I love this question because I'm sort of knee deep in it right now. So I have a beta course going right now, the 0L project, and it's all about like how early can people start preparing for law school? And depending on how much time you have, what can those things look like? So I would break down law school preparation into 4 categories. I would break it down into substantive legal knowledge. So like actually the things you're going to be learning in law school study strategies, practical skills, and career development. So those are the 4 categories that I help law students with and help them prepare and really use that time before law school to be as efficient and effective as possible. In terms of what I think personally, okay, two things. It depends on how much time you have. Like, are we talking about 6 weeks to prepare, or like one of my students is going to apply for the 2022 cycle, so he has a year and a half to prepare for law school? Like, it will depend on how much time you have and how much time, hours wise, week to week, you want to invest. But what I personally would say in sort of like the traditional time that people start to prepare for law school, which is like the summer before, law school strategies without a doubt are the most important piece, because the other things, I would say law school study strategies are a need to know. Everything else is a nice to have. So if you have the time by all means, I would love to dig into practical skills, legal knowledge, and career development for sure. But if we're talking about the brass tacks of what you need to know in order to get the most out of your semester and your year, law school study strategies. One of the things I guess I will say in terms of like the practical skills. So if we're talking like a lot of time out, not really ready to kind of dig into the nuts and bolts of studying, but just kind of interested in like soft starts to like what we can do. The 3 practical skills that I think are the most helpful, again, nice to have, are your writing skills, your public speaking skills, and your typing skills. So all 3 of those things are things you can like kind of sort of start to do, so like low key on the side, if you want to. I'm not saying you have to, but for example, if you cannot type at all, like starting to learn how to type is going to be a really big asset for you, because that has everything to do with taking notes in class and writing final exam answers to maximize points. Same thing with public speaking. Like if you know you want to go into litigation and you have time on your hands and you want to take a public speaking course or go through Toastmasters, by all means, you can totally do that. And then in terms of writing is tough because it takes a lot longer to get better at, but there are writing courses out there that you can start to take. And so, yeah, those would be like the 3 practical skills I would say they're like a nice to have if you are starting far enough out and you have the inclination to improve upon them.
Awesome. Thank you so much, Angela. We're out of time. We're going to be having our next session soon, but wanted to say thanks so much to Angela. And one thing I wanted to say, Angela said she didn't go to a T14, but she did graduate summa cum laude, so she knows exactly what the heck she's talking about on any of these things. And Angela, I know you have a YouTube channel. While we're going off to the next session, could you do you have any information you can drop in the chat in terms of how people can reach out to you? Let us know, or in particular.
Yeah. So the easiest way, so I'm on, YouTube channel, Instagram, LinkedIn are sort of like the common ways to reach out to me. But if you're interested in getting more support or more insight into your law school journey, I run a free Facebook group, Law School Network. And so if you go to Facebook, search Law School Network, that is a community of people who are in law school or prospective law students. And I'm in there all the time answering questions, and just an amazing supportive group of people. So Law School Network is probably the best way to, if you're looking to like dig deeper or like at least start to think about things that you can do to prepare for law school, that's the best way to do it.
Awesome. Thank you. Well,
Thanks for tuning into the show. Please subscribe if you haven't done so already to be notified of new episodes as I release them. And feel free to reach out if you need anything at all as you move forward with your prep. I'm happy to help however I can. In the meantime, I wish you all the best and take care.